Welcome to this second lecture relating to Chapter 5 of our textbook. We're going to continue to be talking about constitutional law. As we covered in the first lecture, we talked about federalism, checks and balances. We talked about the Commerce Clause, the Dormant Commerce Clause, and also the police power. And we're going to move through the Constitution to the U.S. Constitution and now talk about the taxing power that the federal government has. And again, we're focusing exclusively on the federal government in this section. So we're not talking about the rights that the state of Texas, for example, would have to collect taxes against its citizens and residents. There's two main places in the U.S. Constitution that we look to for taxing power. The first part, this section, is actually in the body of the Constitution. It says, "The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States." That did not provide for an income tax. In fact, we did not have an income tax in the United States until 1913, and it required a change in the Constitution. This was actually an amendment to the Constitution that allowed there to be a federal income tax. And here's the language of this amendment. "The Congress shall have power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states, and without regard to any census or enumeration." So that's the authority to have income taxes on the federal level. So let's move on to privileges and immunities. I don't really like the name of this particular clause. Let me go ahead and make this big. I don't think it necessarily suggests what is included in this. So this is the clause in the Constitution that ensures that each state has to treat citizens of other states as well as it treats its own citizens. An example of a privilege and immunity clause situation might be this. Imagine that I have a successful car wash business. I have several locations, we'll say in Sherman, Texas. Making a lot of money. Maybe I'm advertising on the local television station, and I decide I want to expand my business, and I thought, well, why don't I expand into Durant, Oklahoma? It's just across the Red River, not very far. Many of the people in Durant routinely come to Sherman and have seen my car washes, and they probably appreciate having one in their own community. So I start scouting out locations in Durant, and I find one that seems especially appropriate for my business, but it's not zoned the way that I would need it to be zoned in order for me to build my car wash there. So I petitioned the zoning board in the city of Durant for a change in the designation. And the zoning board says to me, well, we're excited to have your business here, Groover. We want you to build your car wash here. We think that you will employ lots of Oklahomans, and lots of Oklahomans have dirty cars, so they're going to find this business useful to you. But there is one thing we need you to do. Right now, you're the only person who owns the business, and we're aware of the fact that you're a Texan. And so before we're going to make this zoning change for you, we're going to require that you get some Oklahoma investors in your business. And in fact, it has to be majority owned by Oklahomans, because after all, Durant is in the state of Oklahoma. Well, that would be a violation of the Privileges and Immunities Clause. States can't require that, states can't prefer their own citizens over the citizens of other states in the United States. Now, there are some exceptions to that, and the rule that we see here is, here we go, we'll use a highlighter, is substantial reasons. There aren't a lot of substantial reasons out there, but there's one that you're probably quite familiar with. Most of us are. It's the one that kind of strikes us immediately, and that is that we have in-state tuition rates and out-of-state tuition rates. So if you wanted to go to, say, UNT, you would be, and you have been in Texas for at least a year, then you would be paying in-state tuition. But if you wanted to go to and I can't remember the name of the university that's in Durant, Oklahoma. I think it might be Southwestern Oklahoma State or something like that. Anyway, we'll just call it that for the sake of argument. If you wanted to go to Southwestern Oklahoma State, you would not get in-state tuition, you would get out-of-state tuition, which might be significantly more than the UNT rate. And that sounds like it's a violation of this privileges and immunities clause, but it's been considered an exception because of this substantial reason. And the idea is, well, if you've been living in Oklahoma for some period of time, you've been paying taxes to the state of Oklahoma, and the state of Oklahoma uses those taxes to offer reduced tuition to its residents. And so since you're paying taxes, it makes sense that you get the reduction. Similarly, if you've been living in Texas, presumably you've been paying taxes, or perhaps your parents have been paying taxes, and therefore it makes sense that your family ought to benefit from that. So there is this one pretty significant exception, but for the most part, Oklahoma or Texas or any other state can't prefer its own citizens. Here we go. Okay, the full faith and credit clause. And here's the language from it. The full faith and credit shall be given to each state, in each state, to the public acts, records, and judicial proceedings of every other state. So let's imagine that I sue Bob in Nebraska. I get a judgment against him in Nebraska. He's supposed to pay me $100,000. I go to a court in Alabama where Bob happens to own some property, or maybe has a bank account there. And I say to the court there, hey, Your Honor, I have this judgment from Nebraska saying that Bob owes me $100,000. He has money here. I'd like to use this judgment to get that money. Well, the court in Alabama will have to honor that judgment. The court in Alabama cannot require that the case be retried. They can't say, well, you know, we're not sure if those Nebraska judges knew what they were talking about. We think they might have been biased against Bob. No, they are going to enforce the judgment because of the full faith and credit provision in the U.S. Constitution. Let me give you some examples about, well, I mean, obviously that was an example how it played out, but historically, let me explain how this can play out and give you a couple of examples. Let's go back in time. Let's go back, say, to 1940s. This was kind of a common theme in movies back at one time. Two young lovers, kind of in a Romeo and Juliet situation. They decide that they're going to elope, but they're underage. At that point in time in most states, the age for getting married without parental consent was 21, at least for boys. Sometimes it was lower for girls. Anyway, these two young lovers, maybe they're both 17 or at least under whatever the age is in their state. But they know that if they cross the borders, maybe into an adjacent state with a lower age of consent, they're going to be able to marry. So they decide, they plan their elopement, they cross the state line, they legally marry in the other state, and then they drive back home and they announce to their parents, we're married. The parents are furious. I can't believe you married that person. I can't believe you got married so young. We don't agree with this. The laws in this state require that you be several years older before you can marry without our consent, and we are not giving the consent. Well, the reality is that the parents can rant and rave all day long, but almost certainly that couple is lawfully married because even though, let's say it was the state of, I don't know what the rules were in each state, but we'll say it was the state of Ohio where the couple lived, and they went to the state of West Virginia to elope. And so even though the state of Ohio would not have permitted these lovebirds to get married in the state of Ohio, the state of Ohio has to honor the marriage certificate of the state of West Virginia. There are, however, some exceptions to the full faith and credit rule, and one of those exceptions is if there is a fundamental public policy against whatever it is that the other state permitted. Let me give you two examples of that. The first example is one that we'll talk about later in the course, so I'm kind of introducing a concept a bit early, and that is the idea of non-compete agreements. A non-compete agreement can arise in lots of different contexts, but the one that I'm going to talk about right now is an employment-related non-compete. So I go to work for Bob, and Bob wants me to sign a non-compete agreement in order to maintain my employment. I reluctantly decide to sign this, and the non-compete prohibits me from working for a competitor for some period of time after I leave the employment of Bob. Well, I work for Bob for a time. I decide that this isn't the right job for me. In fact, I get another job with a competitor, and I leave his place of employment. Bob finds out that I've gone to work for a competitor, and he sues both me and the competitor, saying, Groover, you violated the terms of our non-compete contract, so you are in breach of contract. And my guess is that your new employer was aware of the contract, and so it is tortiously interfering with our contract. And so I'm suing on that basis. And I might say, well, Bob, you and I entered into this contract in Texas, and that non-compete we entered into in Texas was lawful in Texas, but where I'm working now isn't in the state of Texas. Well, Bob would make the argument that it's like the eloping teenagers. Well, okay, I understand you're in a state that would not allow you and I to enter into the same contract that we entered into Texas, but we do have this binding contract under Texas law that we entered into while we were in Texas, so this other court ought to enforce it. It is true that in many jurisdictions, the court would enforce that particular agreement, but there's at least one state in which the court would not enforce that, and that would be the state of California. California has what it describes as a strong public policy against enforcing any non-compete. As far as I know, it's the only state that has this policy. It's actually in the state constitution, and so that state won't enforce any non-compete no matter how generous it is to the employee. And because it's such a strong state public policy, the full faith and credit clause of the Constitution is deemed not to apply because of that very clear statement of the state of California. Let me give you another example, and this is something that is a little bit touched on in the textbook. The textbook in this chapter talks about the Windsor case. The Windsor case has to do with same-sex marriage. It has to do with the right that the Supreme Court has found for people who experience same-sex attraction to be able to marry somebody of that same sex, and for that relationship to be considered a marriage, and entitling the couple to all of the rights and privileges that avail to a married couple in the United States. And again, this was a constitutional right. At the time of the Windsor decision, there were several states that permitted same-sex marriage, but there were also several states that did not permit same-sex marriage. And in fact, many of them had statements that this was against the public policy in their particular state. And one of those states was our state, Texas. In fact, we had a constitutional amendment that said that marriage should be limited to one man and one woman, and we had a statute to that effect. And the Attorney General had litigated this subject to some extent to advance his perspective that this was a fundamental public policy of the state of Texas. So let's imagine, though, that we're in the time period before the Windsor decision. So the U.S. Supreme Court has not expressed an opinion about same-sex marriage. So at that point, there were some states where it was the law of the land, and that two men could marry and or two women could marry in those states. But then there are other states in which those types of marriages were not permitted under the law. So we'll imagine that we have Bob and Larry. Bob and Larry are a romantic couple. They live in the state of Texas. They decide to travel to Massachusetts. At the time they travel to Massachusetts, Massachusetts recognizes same-sex marriages. So Bob and Larry decide to get married while they're in Massachusetts. They follow all of the requirements under the state law of Massachusetts that provides for marriage. They get the marriage certificate, they wait however many days, whatever the procedure is in that state to memorialize a marriage, that is what they do. Then sometime after that, they return back to Texas, and they represent themselves to people as married. They remain in this relationship for a few years, but then Larry and Bob have a falling out, and they separate, and they want to have a documentation that they are no longer a couple. And so they will say Larry files for a divorce from Bob. And of course, because they live in the state of Texas, the only place that they would be able to get a divorce would be in Texas, because there's residency requirements for a divorce. Most states require 6 months residency. As far as I know, there are no states that require just a few days. So you can't go for a weekend and get a divorce or something along those lines. So so Larry files for divorce the only place he can in Texas from Bob. Bob consents to the divorce. He also wants this marital relationship to end. But what the state of Texas would have done at that point is the state of Texas would have intervened, and it would have told the judge, or would have asked the judge not to grant the divorce. And the reason that the state of Texas would take that position is not that they want Bob and Larry to remain married to each other. Actually, it's the reverse, that the state of Texas at that time, again, this is all pre-Windsor, also pre-Oberfell, that their position is that Bob and Larry are not married while they are living in the state of Texas. If you're not married, there's no need for you to get a divorce. So let's assume that the judge agreed with the state of Texas and refused to grant Larry and Bob a divorce because, in the opinion of that judge, Bob and Larry are not in fact married to each other. So Bob and Larry go about their business, and it just so happens that Bob decides to marry Suzanne, who is a woman. Bob and Suzanne get married, and they get married in the state of Texas. They follow all of the procedures that are required for a lawful marriage in the state of Texas. They live happily there for several years, and they decide one day that they will go on a vacation to the state of Massachusetts. They go to the state of Massachusetts. Well, as soon as they cross that state border, at that moment, Bob becomes a bigamist, because the state of Massachusetts considers Bob married to Larry. And now, of course, Bob is representing that he's married to Suzanne, which means that Bob, in the state of Massachusetts at least, has 2 spouses, which makes him a bigamist, and I'm sure that's a crime under Massachusetts law. But you can see how Bob was in a pickle. He couldn't divorce Larry, and so that meant that he would never be able to remarry. He wouldn't be able to marry a same-sex person, another man, or he wouldn't be able to marry someone of the opposite sex because of the fact that some states would recognize his marriage, some states wouldn't, but he wouldn't be able to divorce his first spouse as long as he lived in a jurisdiction that did not recognize it. So you can see how full faith and credit, no matter what your views are on same-sex marriage, I'm just using it as an example of this fact, how it can, when full faith and credit doesn't fully work, that it can create conflicting legal rights and can really kind of muddy the waters. Obviously, after Windsor, all this becomes a moot issue, because now all states have same-sex marriage, and all states recognize the option of same-sex marriages entered into other states being recognized in the state in which they are living, and also permit divorces. So this particular issue with relating to same-sex marriage no longer exists, but you can imagine in the future that there could be other permutations where one state has one policy and another state has a different policy. And this little visual here is related to this. This is a pre-Windsor decision. So we have a minister here, or maybe I guess it's a minister, who is in the state of New York saying, and you have a same-sex couple wanting to get married, till death or crossing the Pennsylvania state line do you part. So his point is, our marriage is only going to get you to the Pennsylvania border, because currently Pennsylvania did not permit same-sex marriage at the time of this cartoon. Okay, let's talk about another provision of the U.S. Constitution. This is the contract provision. So this is an especially apt one for this course, because about a third of the course, maybe even a little bit more of a third of the course, we'll be discussing contract law. And the provision in this contract says no state, so again, we're not talking about the federal government here, we're just talking about state governments. No state shall pass any law impairing the obligation of contracts. Now, this sounds very, very broad. It sounds like, boy, no state can ever regulate behavior that might affect a contract between parties. It's not interpreted that broadly. Actually, it's going to be balanced against the state police powers. Obviously, states have concerns about, public safety. For example, if I enter into a contract to build a house and the general contractor doesn't have its house plan isn't up to the code for that community. I know that it's not, but I want to cut some corners. Maybe I'm not too concerned about surviving. And so I agree to these corner cutting and we enter into a contract. Well, the state can say, no, we're not going to enforce that contract because it's not safe. Well, that would be an issue relating to the police powers. And so they can change the obligations into the contract. They can require the general contractor to do more work to make that house safer. It could even be a situation in which when the contractor and I entered into the agreement, the state did not have the particular regulations that were that became part of the law after the contract was entered into. And then the state comes to the contractor and goes, hey, contractor, you need to add these provisions. You need to do these extra things. You need to put in, say, smoke detectors, or you need to have a certain type of window in each bedroom or something along those lines. The contractor might say, well, when I entered in this contract, those weren't requirements. You are impairing the obligation of contracts. Well, the state would say, maybe we are, maybe we're not, but we have our police power rights, and those are more important than your particular rights under the contract. And most likely they would win. And of course, the test is it unreasonably interfering with an existing contract? Always remember this has to do with states. It says no state, does not reference federal government. We've already talked about this, but just a little reminder, whenever we use the word persons in the law, we are including businesses like corporations, partnerships. It doesn't mean just human beings. Okay, so we have completed the body of the Constitution. Now we're going to go ahead and talk about the Bill of Rights. And these are the first 10 amendments to the Constitution. They were actually contemplated at the time that the Constitution was being drafted. They came about just a few years after the Constitution. So we call them amendments, and they certainly were amendments, but they're not like, oh gosh, we forgot, or we don't know what we were doing, we should have put them in the main body. No, they were a planned addition to the Constitution. Okay, and they're the first 10. So the way I remember it is 10 fingers, 10 bills of rights. The story of the Bill of Rights, well, let me first of all tell you kind of what I expect you to know about the Bill of Rights. I'm not going to expect you to know the numbers, but I am expecting you to know what is in the Bill of Rights. So as we're going through these, do you need to remember that right X is found in the Fourth Amendment versus the Seventh Amendment versus the Ninth Amendment? No. But I do expect that you will know that these rights exist and that they are part of the Constitution. So don't worry about associating them with numbers. There's a few that you probably will be able to associate with numbers, which is good, but it's not part of this course that you need to have that connection. So when the Bill of Rights were first ratified, they actually had a much more narrow meaning than they do today. And we'll see this as we go through them. So I'm going to introduce this concept, and then we'll talk about it more as we go through each one of the amendments. The Bill of Rights, again, as we talked about before, or excuse me, the Constitution generally, including the Bill of Rights, has to do with managing, limiting the power of the federal government. It is not concerned with managing or limiting the power of the state government. Again, the Founding Fathers would have said, well, there's going to be a state constitution that does that. Well, we're focusing upon the federal government at this point. And so when we read the first 10 amendments to the Constitution, they are almost all going to be about the authority, the power, the limitations on that authority and power that the federal government has. So please don't, at least initially, interpret those to be limiting what the state government can do. Another error that sometimes people make is they assume that these protections apply to our relationships with other people. For example, freedom of speech. The federal government can't limit my freedom of speech, that's clear, but I might start thinking, well, my next door neighbor can't limit my freedom of speech. Well, no, there's no constitutional protection there. The Constitution protects us from actions by the government, not by private citizens or even businesses. So if, let's say I was going to a Walmart and I was wearing a t-shirt that Walmart didn't like. Maybe Walmart was supporting candidate X for political office, and I had walked in with a t-shirt supporting candidate Y for political office. As I'm passing through the portals of the Walmart store, the greeter sees that I'm wearing one of these shirts with the other candidate's name on it, and they call security and have me taken out, and they tell me, you cannot come back in as long as you're wearing that shirt. You can turn it inside out and come back in, but you can't come in wearing that shirt. Well, certainly they are limiting my freedom of speech, but that's not a constitutional right because Walmart is not the government, and so they can do that. They can say, don't, when you're entering our property, you can't do this. Now, obviously, it's very unlikely that Walmart would do that unless I was wearing a shirt that was, profane or revealing or something like that. If it was merely political and not, suggesting violence, they're probably not going to care one way or the other. It would probably be bad business on their part to take sides in an election like that. But they'd have the right to if they wanted to. So let's focus upon government action. Let's get started. We'll talk about the First Amendment first. First Amendment is probably the most important, or at least for many folks it's the most important, but it's not the most important from a business standpoint. So we're going to talk a little bit about this and then move on and spend more time on the ones that are directly relevant to a business focus. Okay, so the First Amendment deals with freedom of religion, press, speech, and peaceful assembly. For our purposes, by far the most important one of these is speech. Now, certainly there are businesses that have a religious component. For example, they may be a business founded by a religion or by people who are members of a particular religious group. One company that comes to mind is Hobby Lobby. It's a privately held business that is a profit-oriented business, but the owners are people of faith who have a very serious commitment to certain philosophical and theological issues that are sometimes controversial. Very conservative theological family. Then there can be businesses that are nonprofit, for example, hospitals and charitable organizations that may have a religious component to their mission, and so they may have concerns about freedom of religion. Certainly freedom of press relates to some important profit-making centers such as newspapers, magazines, the press generally, books and the internet and things like that. So in certain niche businesses that can be important. And peaceful assembly, certainly there are businesses that have chosen to lobby for certain actions or actions they supported or opposed, and so that can be a factor. But as I say, the big one, the one that is overwhelmingly the most important to lots and lots of businesses, is going to be speech. That's what we're going to focus on. So what is free speech? Well, first of all, it's not an absolute right. It's not something that people actually, let me go ahead before we go too far down this road. I'm going to just pull up the First Amendment. Let's see, First Amendment. Here we go. Congress shall make no law respecting an establishment of religion Here we go. Or abridging the freedom of speech. Okay, so this is the one that we're focusing on right here. So let me just read the whole thing so you get the whole flavor of the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peacefully to assemble and to petition the government for a redress of grievances. So the one we're focusing on now is abridging the freedom of speech. Okay. So that sounds pretty absolute. It doesn't give any wiggle room. It doesn't say you have this right under these circumstances or you don't have this right under these other circumstances. And this is pretty common. You know, a constitution doesn't get into the weeds. It's almost like what I like to think of as a mission statement. If you've ever worked on a committee in an organization or corporation where you've been responsible for doing a mission statement, you know that's kind of a brief summary of the goals and focus of a particular department or a particular project or a particular business or whatever the focus of your mission statement is. It's not going to capture every detail. It's also going to be kind of aspirational. It's not going to necessarily reflect everything about the real world in it. It's a little bit hopeful, maybe a little hokey sometimes. And so it's not going to think about every single thing that might happen or every contingency that might arise. So while we talk about free speech, there are lots of things that we don't include in free speech. And examples of this would be, let me go back to, would be obscene. Well, that wasn't what I meant to do, was it? Obscene, false, defamatory, or dangerous speech. Speech that is socially inappropriate, you could say. Things that fall into this category, they're not entitled to the protections of free speech. We'll talk about defamatory speech when we get to Chapter 6. We'll even talk about, well, I guess we have to some extent talked about false speech already when we talked about criminal law. But an example of dangerous speech, the classic one is yelling fire in a crowded theater. What'll happen? Well, people will jump up and try to escape, but they'll trample on other people in their desire to exit the theater. And so that's dangerous speech. That would not be protected speech. So there are some things that do involve speech, but it's not always for certain that that will be protected speech. Then there's another distinction, or two distinctions that are important. So we're going to not worry about these categories right here. We're going to now focus upon whether speech is political or commercial. Let me just flip over here for a second. Well, let me first of all talk about the terms, and then we'll talk a little bit more detail about it. So political speech is the most protected. There's almost no limitations to it. Other than the ones we've talked about above. And even in those circumstances, a court is probably less likely to find speech dangerous if it's actually political speech. Because that's the real purpose that we have freedom of speech, is to protect political speech. If I can be arrested for what my political views are, it's really hard to have that in a democracy. Even if my political views are kind of outside the pale, that's not a very welcoming position, and what it's going to do is it's going to chill everybody's speech. And so it's really difficult to have campaigns and elections when people aren't free to speak. So that's the most strongly protected speech, but it's not the only protected speech. Commercial speech, in other words, speech relating to commerce, is also protected. It's just not protected to the same extent that political speech is. It can be more regulated. So let's imagine that I am in the business of I am in the business of selling cigarettes. Well, guess what? I can't advertise my cigarettes on the television. But I could easily say, well, my cigarettes are a lawful product, and many advertisers are permitted to advertise on the television, and so therefore my commercial speech rights are being abridged, my First Amendment rights are being abridged. But the response of the government would be, well, our regulation of your commercial speech is reasonable because, of course, smoking can lead to serious health conditions that the government may be responsible for in terms of caring for that person's health over the long haul. Let me just put up here one little thing for just a second. Here we go. We'll go to the book here. So here we have the Central Hudson test for commercial speech. Central Hudson is an important U.S. Supreme Court case that attempts to and does separate speech into whether it is commercial speech or not commercial speech. So let's look at how that test works. Okay, so we ask these questions to decide whether it's protected or not. The first question is, does the speech concern an illegal activity? Is it misleading? Well, let's consider the case of the cigarettes. So let's assume that the advertisement that I want to put on the television is a lawful activity. In other words, I'm not showing, children smoking. I'm not trying to sell marijuana cigarettes. And I don't misrepresent anything about the product. So the answer here is going to be no. It does not involve illegal activity, is not misleading. Is the government interest served by a restriction on commercial interests substantial? Well, in this case, I would say yes, because showing these commercials could entice people to smoke, to take up smoking, or perhaps to smoke more often. And those individuals many times will lack adequate health insurance, and so the government might be required to pay for their medical treatments. And if they die at a premature age, then their children and perhaps their spouses might be eligible for Social Security benefits, or they may need other help from the government, and so the interest there would be pretty significant. Does the regulation directly advance the government interest asserted? So here we'd have to say, okay, we know the government has significant interest. Is restricting the advertisement so that they cannot appear on television, does it serve that interest? Well, again, that people can disagree, but I think there does seem to be a reasonable connection. Who watches television? In many cases, young people who may be developing their ideas about whether they want to take up cigarette smoking or not. Seeing those commercials with glamorous people smoking might cause them to consider it when otherwise they wouldn't. And finally, is the government regulation more extensive than necessary to serve the government interest? Let's assume that it's not, and so in this case the government would be able to regulate commercials on television relating to cigarette consumption. So this is how you approach this analysis as described in Central Hudson. Let's go back to our presentation. I'm going to go over these really briefly. There are two categories of protections with respect to religion, and these two protections actually, there's definitely some tension between the two of them. So sometimes when a law seems to be very careful about not establishing a religion, so it's very respectful of this clause, it might inadvertently interfere with the free exercise clause. So these two can definitely, there can be a tension between the two of them. Obviously, the first one is that the government can't prefer one religion over another, or one particular flavor of a religion over another. It also can't prefer religion over no religion, or it can't prefer no religion over religion. So, for example, the federal government can't say, we prefer Episcopalianism over all religions, or we prefer Hinduism over all religions. That would not be a constitutional action, because essentially by making that statement, it would be preferring one religion over another. Now, obviously, the federal government would be unlikely to do that, but they might pass some regulations that have the effect of favoring that particular religion over another, and so they might indirectly start establishing that religion. So that's prohibited, obviously. The next, though, is the free exercise. And sometimes the government might undermine the ability of people to exercise their religion freely. So let me give you an example about how these two clauses can make it difficult for I mean, again, sometimes these two clauses kind of butt heads against each other. So imagine that you are the principal of a high school, and it's a multicultural, multi-ethnic, multi-religion high school. One group at your school has come to you and said, we would like to establish a prayer group after a school. We'd like to use one of the classrooms, and you know, we do, in addition to having this prayer group, we also want to offer some additional tutoring resources because this is our public service. You hear that and you think, well, that's a lovely thing. We wouldn't be using that classroom anyway, and so you know, so it's not costing us anything, and if it makes it easier for them to engage in their religious practices, that sounds like a win-win. Plus they're going to help kids too, so that sounds like a good thing. But then another group comes forward and says, we don't like group A being able to use the classroom. We think that you are violating the establishment clause by preferring that group over another group. Let's say that another group came to that principal and said, we are the devil worshippers. You know, we believe in devil worship, and we want to have our own prayer group in the school. And the principal says, no, I don't think that's okay. I don't think I'm going to allow that. I'll allow group A of a more traditional religion setup, but I'm not going to allow the devil worshippers. Well, the devil worshippers complain, and they say the establishment clause is violated because you're preferring one religion over another. So then the principal says, well, okay, I guess I won't allow any religious groups to use classroom space. You know, if a group of students want to meet about religion, they'll have to do it in their own spot, not on the campus. So you feel like, okay, principal, I've solved the problem. I'm not going to have an establishment issue. Well, now the first group, the group that you initially allowed to use the classroom, says to you, well, now you're violating our constitutional rights, our right to free exercise our religion. You're prohibiting our use of religion. After all, this is a public school, so this is funded by the government. You don't have any business telling us that we can't exercise our religion. After all, we're taxpayers. This classroom was built by us just as much as it's built by anyone else. And if we want to worship, we ought to be permitted to do so. So you can see how these two provisions, there's definitely some tension between these two. Let's move on to the Second Amendment. This is the one that, let me just go ahead and put that Second Amendment up here. This is one that gets a lot of publicity because there's some controversy about what it means. People interpret it in different ways, but it has to do with gun issues. So this is what it says: a well-regulated militia being necessary to the security of a free state, and here they don't mean state as in you know, Texas, but they mean the whole country. The right of the people to keep and bear arms shall not be infringed. So what does it mean to keep and bear arms? That's the issue. It doesn't really present a lot of business issues unless you happen to be in the business of manufacturing or marketing or selling guns. And so that's the idea behind Second Amendment. How much regulation can there be of gun possession and gun sale? And so that's kind of beyond the scope of this class. Then we have the Third Amendment, really not an issue. This is the amendment that says that you can't, private people cannot be required to house soldiers in their private residency. So not really an issue that we confront. Okay, so now we're up to the Fourth Amendment. Here we're getting into some stuff that does have relevance to our business side of the things. And this one, let me just go ahead and pull up the Fourth Amendment so you can see what that looks like. The Fourth Amendment applies to individuals, but it also applies to businesses. So here we go. And this is the Fourth Amendment. Let me just make this a scooch bigger. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So here the key concept here is going to be unreasonable searches and seizures. And no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So no unreasonable searches and no warrants without probable cause. Let's go back to the state here. I'm going to pause for just a second.